Wednesday, February 7th. First item of business we have on the agenda is the approval of minutes from January 31st. Can I have a motion to
move that we adopt as written?
Okay. Motion by Representative Johnson, second by Representative Howe to approve. Any discussion? All in favor say aye. Opposed, no. Okay, minutes are approved. You guys have an agenda at your seat. I'm going to jump to the end of the agenda and start out with the Child Abuse Review and Evaluation of the CARE Network and get an update. So I'd like to welcome at this time Carrie Weeks, Dr. Carrie Weeks, pediatrician from Wichita. So welcome. Oh, and before you start,
on. Okay.
Yeah, before you start, I just want to introduce my guest today. It's my grandson, Brooks. So
Very fitting. Very fitting. All right. I'm Dr. Carrie Weeks, and I am a child abuse pediatrician at the University of Kansas School of Medicine in Wichita. Born in Kansas, trained here, and I've been working for KU, been practicing here for almost 20 years. So I'm just happy to be here. So good afternoon to you all. Chair Concannon, Vice Chair Johnson, Ranking Member Ousley, and members of the House Committee on Child Welfare and Foster Care. I'm honored to provide you with an update on the Child Abuse Review and Education or an Evaluation Network. That's also called the CARE Network, established by the Kansas Legislature in 2023 through House Bill 2034. Passage of the bill has set the network on a path to fill its full potential in serving the children of Kansas. We really appreciate your support. And as I speak, I'm going to be referring to a handout that I believe you all received yesterday. So I don't know if you have that in front of you, but you should have all of this information. You might remember this, but the CARE Network's primary goal is to ensure comprehensive, quality medical evaluations are accessible across every region of Kansas, specifically for cases of child abuse. This approach not only reduces the burden on families and investigators, but also strengthens the resources available to local agencies that are tasked with investigating abuse. Within the DCF framework, a written care referral is initiated for every case involving suspected child physical abuse or neglect on children ages 5 and under. Then a board-certified child abuse pediatrician at the Medical Resource Center, that's what we call the MRC, that's me, reviews each case, and then subsequently, the MRC offers a recommendation back to DCF on whether or not that child should have a medical evaluation. So a little bit on our statewide referral system. KDHE has entered into a contract with the KU Center for Public Partnership and Research to tailor the IRIS database and referral system to our program. And the system facilitates a secure and efficient communication between DCF and the MRC, and importantly, it allows for data tracking and program evaluation. So just giving you a little bit of updated data today, from June 1st, 2023 to January 31st, 2024, so just over 6 months, DCF transmitted a total of 2,056 referrals to the MRC. Among these referrals, 267, which is roughly 10%, were directed for general medical evaluation, and I would think that would be mostly like your primary care provider. 228 children, another 10%, were referred for a care exam to the local care provider, and 14 cases were referred directly to the MRC because they needed specialty evaluation by a child abuse pediatrician. Notably, the average response time between the submission and recommendation was 13 hours, so we have a really good response time with the MRC. Table 1 in the handout really gives you a breakdown of the outcomes of the referrals, and one thing you might notice of that 2,056 total referrals, a little over 1,300 of those did not require any sort of evaluation. So just to make a note, most of our referrals, actually, we do not refer for an evaluation, medical evaluation. The CARE Network serves all of Kansas, and Table 2 demonstrates the referrals sent to the MRC by DCF region. And the 5 counties receiving the most referrals were Sedgwick, Shawnee, Wyandotte, Johnson, and Reno County. I just wanted to give you a little bit of more information about our CARE Network and update you there. The CARE network is really consisting of a team of trained care providers, and a care provider is an individual that's holding a valid license to practice medicine, an advanced practice registered nurse, or a licensed physician assistant who has, and a big shout out to Western Kansas in the southeast part of the state where we have really grown our CARE network. So a little bit more on the training and mentoring. We have, again, that three-prong. So starting in 2022, the KAAP, in close partnership with the MRCs, has been coordinating specialized training, continuous education, and mentorship to all the care providers. We do an intense 2-day training in the fall, and that's overseen by the MRC. And then to date, we have successfully trained 52 providers across 20 Kansas counties. Notably, the majority of care providers who underwent the training were MDs or DOs, so physicians, comprising about 58% of the participants. And there's a table in your handout that shows the categories of the trainees. I would also like to note that I'm at KU Pediatrics, and we have built this training into the curriculum for our PEDS residents. So we are training our future pediatricians for Kansas with this curriculum. In addition to the initial training, KAP coordinates continuous training for maltreatment through an annual webinar-based training series. So we do the 2-day intense training in the fall, and then we follow it with a 6-session ECHO series in the spring. I'm the main facilitator for that ECHO series. We completed our first ECHO series last spring, and then we just started our second series and had our first session in January. So care providers also benefit from peer review and mentoring provided by the child abuse pediatricians associated with the MRC. So anytime we have a pediatrician that's a care provider, maybe out in the rural areas, if they have questions or concerns or a case, they have directly access to a mentor that they can call and review cases with in real time or at any time that's convenient for them. So we are there for them. Recently, the KAP has established a new provider onboarding session, and this has been really helpful, I've heard, aimed at acquainting not only the care providers, but their upfront office staff, their billing personnel, and other members of their medical team about the program. And that has been really helpful. We've realized that a lot of the care providers in rural areas, they've needed to get their office staff on board on how to handle referrals when they come in, how to bill for these and such. So KAP has taken a role in that. In closing, I'd like to underscore the significance of a coordinated, comprehensive medical response in safeguarding Kansas children from abuse and neglect. Kansas has assembled a dedicated and robust team, starting with the Kansas Legislature. The passing of House Bill 2034 furnished both the authority and the necessary funding to establish the Care Provider Network program. Thank you so much for your support of this program, and it will help safeguard the well-being of Kansas children for years to come. I'd like to conclude by sharing one of many success stories generously provided by a DCF worker. With the growth of the CARE network, we've seen an increased collaboration among professionals in many of the communities, and that's now including the care provider. For example, in one rural community, the local child advocacy center was completing a forensic interview on an 11-year-old girl, actually for concerns of sexual abuse by her mom's boyfriend. But in that interview, the girl disclosed ongoing physical abuse of her 3 younger siblings. So the CAC worked with DCF and law enforcement to ensure the safety of all of those children. And then DCF placed a care referral through IRIS. So the MRC, so our child abuse expert team, recommended based on the concerns that all of those younger children have a medical examination. All 3 children were taken to the local care provider for medical evaluation. One of those children, the youngest brother, was noted to be underweight and had numerous patterned marks and bruises. The care provider was able to work with DCF to confirm that the child's disclosure of abuse was consistent with the injuries she was seeing, and the care provider was able to make a diagnosis as well as appropriate medical recommendations for that child going forward. The collaboration between the CAC, DCF, local law enforcement, and the care provider was critical in keeping this child and siblings safe for the future. In this particular case, those children were put in foster care, and law enforcement was able to make an arrest in that case. Thank you again for the opportunity to present the Care Provider Network and just highlight the continued progress we've made. I am here for questions at the appropriate time. Thank you so much.
Thank you, Dr. Weeks. We'll have questions now, committee. I'll start us off. you mentioned that you are working this into med school curriculum. What year and what's that look like?
Yeah, so that's actually through a separate federal HRSA grant that we have through the school, it's called the AIM High Grant. It's a multi-year grant that's focused on training residents in mental and behavioral health, which is, we all know, is super important. And they felt like this training and being able to identify and work with victims of abuse and neglect should be part of that. And so we are trying to include all of our residents. They are here for 3 years. So one of those 3 years, each one of them will have the opportunity to come to our training. We've also invited family practice residents and med peds residents to that training if they can make it as well. So we're really trying to make this accessible to our residents in the area.
That sounds great. Committee, do we have other questions? Representative Humphreys.
Thank you. It's not really a question. I just want to welcome Carrie, who is my neighbor and constituent. Yes. Thank you so much for being here. Excellent presentation. Really appreciate what you're doing.
Thank you.
It's good to see you up here as well as in the neighborhood.
Me too.
Representative Wagoner.
Thank you, Madam Chairman. One or two questions on your data. On page 1, you say it was from June 1st, 2023 to January 31st, 2024, but your table number 1 says to August 31st, 2023, and I'm wondering what is the proper date, or how many months is being covered with that table 1?
I think that's probably a typo. Because I know for a fact we didn't do 2,000 referrals in just a 2-month time period. Would that be fair to say, Danae? Yeah. So that should say through January 31st.
Okay. And then if I may, so I'm just trying to interpret this again. So of the 2,000 plus whatever kids you looked at, you basically had 1,300, 65% had no, further information, I guess, needed, required. So the rest of are there different levels? I'm just, the care provider or the child abuse pediatrician needed, or medical examination by a general practitioner? Was that just neglect, or just like the kid had some issue? Or, how many of those were actually like child abuse, suspected child abuse cases?
Absolutely, and I can kind of walk you through maybe some of those levels and what type of referrals those are. For the medical exam by a general practitioner, for me, those are typically cases of neglect where there's concern of malnutrition for the child, concern of medical neglect of the child, or maybe there's concern of they were found in a neglectful situation. There's concern that they're significantly developmentally delayed. So something where they don't necessarily need a physical abuse evaluation, but they definitely need to be rerouted back to their primary care. So that would be that subset of kids. The medical exam by a care provider are typically kids with marks. So they are kids that have concerns of acute physical abuse that we oftentimes DCF, when they make the referral, they're able to attach photos and medical records for us. So we review those photos, and if we see marks that are concerning, we will then refer, hey, you actually, yes, they do need to be seen by a care provider in your local area. The cases really sent straight to a child abuse pediatrician would be cases of severe abuse where there's concern of maybe abusive head trauma or something where the child might need more specialized services and just more difficult cases. The cases going to the emergency department are pretty rare, but that would be if obviously it looks like there is an immediate urgent medical need for that child. And then case review would be maybe the child was seen in their local emergency department and they had the appropriate workup. So medically they have been seen, but it really hasn't been looked at by anyone with specific expertise in abuse. So in that situation, we gather the information. Instead of having that child seen again, we look at all of the information that, all of the medical records, and then help determine, did that child receive all of the medical studies and tests that they need? And then what do we need to do from there? So.
And so, I mean, of course, I remember the hearing from a year ago, and I know part of it was that you were thinking you'd have a higher level of catching cases versus just having a general practitioner who didn't necessarily, or somebody wasn't specifically trained. I mean, you're convinced it definitely has panned out? I mean, that you guys are really catching more? I mean, is it clear? Is it, I don't know, is the data shows this? I mean, what's your, you know, statistical sort of, knowledge now of the topic?
Well, we know that about 10% of these kids are being referred for care exams. I can talk specifically about my community in the last 18 months. So the last time I looked at my data was actually before we started the care program, and then I just looked at my data last fall. And our team, my team in Wichita has seen double the amount of kids. And it's not because we have double the abuse. It's because the kids are being identified, they're being appropriately referred, and we have a streamlined referral system to get them in. So I definitely, I can say for my community, who was actually, I feel like, doing a pretty darn good job at the get-go, we have actually doubled the amount of kids we've seen. Yeah.
Other questions? Representative Pickert.
Thank you, Madam Chair. Carrie, thanks for the presentation. And I'm a retired nurse with a lot of pediatric experience, so it just makes my heart happy to see that everybody's working together, the care and the child advocacy centers and law enforcement and all that. And see something, say something is worth it, even though so many weren't needed to be examined. So I just think it's really a neat program. Thank you.
Thank you.
Mm-hmm.
Representative Neighbor.
Thank you. Carrie, you said your number of cases had grown, but it wasn't because there was more abuse. Is that because more people are aware of what needs to be referred, or how do you correlate that?
So because we have a standard referral system, it's not up to the DCF worker or the law enforcement person to decide whether a child may benefit from a medical exam. That every kid is being referred, and then we are making that decision. And we know what to look for. We have a better sense of who needs an exam. And so I think we're doing a better job of identifying the kids that would benefit. When previously there were probably children that would have benefited from a medical exam that were not offered one or sent for one, if that makes sense.
Thank you, Madam Chair. And by the way, can I borrow your grandson? No. Thank you.
Further questions? Representative Humphreys.
Thank you for letting me come back. So there was one question I had, even when we were going through all of this. Do you find any reluctance or hesitancy on the account of the parents, like not wanting their children to have exams? Or how do you deal with that if there's a parent that's not cooperating?
I would say that's probably a better question for DCF. Because by the time, we see the children, they've accepted, they've been willing to have their child seen, and they've made the call and made the appointment to get to the exam. And by and large, I feel like we have good rapport with the families that are there, and they're very cooperative. But I am sure that there are families that are reluctant to have their kids examined. And like I said, that would probably be a better question for DCF.
Thank you.
Yeah.
Representative Astley.
Thank you. Thank you, Madam Chair. Thank you for being here. Thank you for the presentation. It sounds like it is, that was for folks online. It sounds like it's working as intended, but I am curious on your table one here under the rejected, what you've got 17 cases, and if you went over that during your presentation, I apologize for not catching it, but I'm just curious to learn a little bit more about that.
Yes, I'm so glad you brought that up. That represents the learning curve early on. So within the IRIS system, you have to either accept or reject the referral. And as the MRC, we were trying to figure out the best way to get more information. Sometimes someone will send us a referral and we have additional questions. And so there was just a learning curve where we were trying to figure out the best way to do that. And very quickly we figured out rejecting the referral was not the way to go. We actually needed to accept it and then use the system to communicate both bidirectionally. It's a very user-friendly system. So those all were my guess, very early on. I haven't rejected a referral forever. It was just kind of part of that early learning curve. Yeah.
And then I guess follow up, if I may, Madam Chair.
Mm-hmm.
CPS did not respond to a request for additional information within the time allotted. Is this something to be concerned about, or is this something that's been ironed out as well?
So we actually have a system for that, and right now, if we ask for additional information, we have a little comment box, and we say, "Hey, could you give us this information?" And it actually alerts that DCF worker by email to comment, and if we haven't heard from them in a couple of days, I will often just email them and say, "Hey, see, Iris, don't forget to get back to me." We are actually going through a process of brainstorming on, are there ways we want to make the IRS system work better, or our communication system work better? And that's one of I don't know if it's really a bug, because we found a workaround, but one of the things that we want to streamline and make more user-friendly. And so that will be something that we look at in the future. But right now, I would say we have a process to address that. Yeah.
Thank you for that, and I think the committee stands ready to support you as you navigate these changes. Thank you, Madam Chair.
Thank you.
Any other questions? Okay, thank you so much for being here, and hope you're enjoying your day at the Capitol. Okay, good. Okay, committee, back to the top of the agenda. I'm going to open up the hearing on House Bill 2552, and we'll ask Jesse, let the room kind of clear out, and then. Lots of pediatricians here today. So, yeah, Jesse, can you explain the bill?
Yes, thank you, Madam Chair. Good afternoon, committee. This hearing is on House Bill 2552. So 2552 amends an existing statute in the Sync Code, and that statute determines how the expenses of care and custody for a child in need of care are paid. So what this bill does is it proposes a new subsection to that existing statute concerning federal benefits that may be received by a child in need of care. So that new subsection D would direct the secretary to determine whether a child that is in the secretary's custody is eligible for federal benefits. So when we're talking about federal benefits, we're kind of talking more SSI, we're talking veterans benefits, et cetera, like that. So if that child is eligible, then this section requires that the secretary apply for those benefits on behalf of that child. And then when the child receives the benefits, and the court will usually appoint the secretary, since the secretary is in custody of the child, appoint them as the payee for that amount of benefits that the child is eligible for. This section requires that the secretary not use those funds to reimburse for the care of the child. Instead, it sets out that the secretary may use those funds for the child's unmet needs beyond the care and custody of the child. And in doing so, they shall establish an account for the funds for the child. And those funds be used for a child's future needs as well. The secretary then is required to provide accounting of that account of those benefits, and report the accounting to parents if parental rights have not been terminated. So if benefits applied for by the secretary on behalf of the child are denied by the federal government, then the secretary will consult with the child and the legal guardian on whether or not to appeal that denial. And then lastly, this adds a definition to the section of what unmet needs means. So the section directs that the funds are to be used for unmet needs of the child. And so that can include tuition, tutoring and training, transportation for work, any educational items, help to maintain family connections, possible housing expenses if the child is of the older age, and items related to a child's hobby or an interest, such as technology or clothing, instruments, books, or other equipment that may support that hobby and interest.
Okay, are there any questions for Jesse? Representative Howerton.
Thank you, Madam Chair. Is there a definition for care and custody? What does that entail?
Yes, Madam Chair. off the top of my head, I don't think 2202, the definition section, includes a definition for care of custody. And this section does not define that either. I don't want to speculate what all things may be included per what the secretary currently uses those funds for. So that's probably for DCF.
Other questions for Jesse? Okay, thanks. Okay, we'll start with the proponents. And up first, I have Amy Harfeld, who's joining us via WebEx.
Good afternoon, everyone. Can y'all hear me?
Yes, we can. Good afternoon.
Excellent. Well, members of the committee, I appreciate you allowing me to testify virtually. My name is Amy Harfeld, and I serve as the National Policy Director for a children's rights nonprofit organization called the Children's Advocacy Institute. I have been a child welfare attorney and foster youth advocate for over 25 years. I mostly focus on trying to help support states who want to strengthen the rights and economic opportunity of young people who are in foster care and aging out. I'm here today in support of HB 2552 and really applaud your notice of and action on this issue. I got into this issue when I was representing a 17-year-old who wanted to emancipate from foster care many years ago when I was in family court. And this was a real go-getter who had finished high school early, been accepted to college, and though she'd been living in care for years, had saved up $13,000 working in her uncle's deli for a number of years so that she could help herself launch after leaving care. She called me in a panic one day and said, "Ms. Harfeld, I just went to get my tuition deposit for my savings account. And they said my account is frozen and I can't access my money." And it was the state who placed a hold on my account. And I said, "Well, that's crazy. Let me look into this for you. Of course, I'll fix it." And after some looking into it, I realized that when she had entered foster care, the agency had automatically screened her for benefits to see, I know it doesn't sound nice, but if she was worth any money. They had automatically applied for benefits on her behalf without ever telling her or me or her any remaining relatives. She was actually eligible both for survivor benefits because her mother passed, which is why she had entered care, and for disability benefits because she had a serious mental health condition that emerged after she entered care because of some other related trauma. So both of these sources of benefits had been applied for by the foster care agency, which appointed itself to receive her checks. And that money was spent allegedly, I guess, to reimburse the agency for the cost of her care, which is sometimes termed as maintenance, for the entire time she was there, without her ever knowing that anybody had applied for her benefits, without her attorney ever having notice of this, without being allowed the chance to say, "Hey, I have a relative or a family friend who cares about me, who could have managed her benefits in her behalf." And then to add insult to injury, in fact, the state did freeze her savings account because when you receive disability benefits, you can't possess assets greater than $2,000 or you lose your eligibility. So in fact, the state had frozen $11,000 of her $13,000 bank account, allegedly on her behalf to allow her to continue to be eligible for these benefits that she never knew about and never saw a dollar of. And in fact, in that case, she did have to defer college for a semester because she couldn't make the tuition deposit. So I can imagine that's not what we want to happen to our young people who are leaving care. And as an attorney and a constitutional geek, really offends some basic notions of due process to just imagine having your own Social Security account raided by a public agency without ever learning who was taking it, what it was for, or having a chance to make a case for a use that might benefit you now or into the future. In Kansas, this happens just as it does in many states. But as in many other states, there are really active efforts on the ground across the country to change this policy. You know, they say when you know better, you do better. And this is a policy that's really happened in the shadows for a long time. And I think most agencies have really perpetuated the practice, just assuming that it was within the bounds, without really reflecting on the impact on young people and frankly on Kansas taxpayers who end up picking the bill up later when we send young people off aftercare without resources. And there's a high likelihood that they might end up reliant on other services and benefits down the road without a chance to launch themselves with their own assets. 100% of kids' assets are their personal property. They should be used according to the Social Security Administration for costs that exceed the existing obligations of the state. According to federal law, Title 4E, when a child is removed from their home and placed into care, if they receive any money from the federal government, which all agencies do, they are explicitly required to pay for the cost of caring for every child that comes into care. They can't pick and choose which kids they cover the care of. The state can receive some federal dollars to reimburse itself for some of the cost of the care if a child is eligible, but they ultimately are responsible for caring for every child. When they take a foster youth's disability benefits or survivor benefits, what it amounts to ultimately is charging disabled kids and orphans for their own foster care, while the state goes ahead and pays for the foster care of all other children. And as my 9-year-old said when he saw this featured in a news segment, he said, well, that doesn't seem very fair to take their money without letting them know and only to make those kids pay for their care. I agreed with him. Kansas joins a growing barrage of states who are trying to address this. We now have 28 states and jurisdictions across the country, mostly over the last 2 years, that have introduced and advanced bills to fix this issue. I need to applaud 2552, which you have before you. I have testified in front of over a dozen state legislatures on similar bills. This is a really great bill. It's comprehensive. It's very thoughtful in addressing the different pieces of this that need to play out on behalf of youth. It's a good thing that the agency actually screens them and applies for benefits. I'm sure if you had a child or a grandchild who had an emerging disability, you would want to make sure you knew what was going on and that they were getting all the services that they needed to thrive. And so when the foster agency is serving as the legal parent, they're being a good parent by doing that and making sure that a child's needs are met. I want to express gratitude to the committee for bringing this up, to our sponsors, and just urge you to advance the bill on behalf of Kansas youth now and into the future who desperately need access to their own funds to help them launch successfully into adulthood. I appreciate your time. Thank you.
Okay, thank you. I think we'll hold questions till we have heard from all the proponents. I'm going to add in a proponent if he's online. Is Justin online on WebEx? Okay, Justin.
I'm right here.
Hi,
Yep.
welcome to the committee. We don't have any testimony. We didn't receive any testimony from you, but I appreciate the fact that you called and asked to testify. Could you go ahead and talk to us a little bit, and then we'll need you to email some written testimony for the record.
Yeah, absolutely. Yeah, members of the committee, first and foremost, thank you for the opportunity to testify today. It's an honor to be before you. Currently, foster youth receiving Social Security benefits have their money covertly taken by the government with no recourse or notice. This issue holds deep personal significance for me because when I was 13 years old, my father passed away from cancer, and we began receiving Social Security survivor benefits to help make up for the lost income after his passing. And unfortunately, my mother also struggled from substance abuse. So many responsibilities of managing my family's finances fell on my shoulders. So I was very aware that these benefits were coming to our family to support our most basic needs. Unfortunately, we were eventually became under the auspices of the court and were later placed into foster care. And that the first thing I noticed is that the checks that we were receiving suddenly disappeared. And after several months of prodding my caseworker, I discovered that the state was actually taking those benefits, and they offered, again, no recourse for me to be able to get those benefits. And in total, just me personally, they took over $18,000. And then, when I left foster care, that, I had a lot less support because of that, because I didn't have the same, I didn't have the amount of money that I would have had had the benefits not been taken. And, those benefits could be used for things like buying your first car, getting your first apartment, going to vocational school, going to college, or whatever post-secondary plan you want to pursue. And it really limits your options when the government takes away, those resources that your family paid into. You paid into Social Security, and to have that taken away from you is just really difficult. While I was in foster care, I wanted to try to rectify this wrongdoing, so I reached out to all my public officials, and regretfully, I did not receive any response back from them. So the next thing I did is I found a school teacher who was running for public office, and actually went out and knocked on 10,000 doors after school and on the weekends. And despite being outspent 10-1, our campaign emerged victorious, and we won by about 500 votes. And I was fortunate enough to earn the opportunity to work in the Michigan State Legislature for about 2 years, and then later in the United States Congress, where I advocated for legislation similar with similar intent as House Bill 2552. And I'm just here today to implore you to support this bill, to give foster youth a chance at success, and to give them access to the funds that are intended for them. So I just implore you to vote to advance this legislation, and thank you so much for the opportunity to testify today.
Okay, thank you, Justin. Could you state your name and spell your last name for us?
Yeah, sure. It's first name Justin, Justin, last name Kasieta, Kasieta.
Okay, and are you testifying on behalf of any organization, or in what capacity are you?
Yeah,
here
it
for?
would be, I would say, with the Children's Advocacy Institute, because I work with Amy Harfeld, the
Okay.
previous, yeah.
Okay, all right. Thank you. We may have questions for you. Can you hang on?
Sure.
Okay.
Yep.
Thanks. Okay. Let's see. Next we have Kendall Seal with Center for the Rights of Abused Children. Sorry, my agenda is being colored on right now, so
That's pretty awesome. Okay. Chair Kincannon, members of the committee, Kendall Seal, Vice President of Policy for the Center for the Rights of Abused Children. By background, I'm actually Kansas lawyer and lobbyist. You've already heard some of the broad strokes kind of background on this. The total population estimated to be impacted is 10 to 20% of the foster youth population. I don't know that that number is fully accurate, because if we're not doing ongoing screening for youth who may have emerging disabilities, we may not be detecting that they need those supports. So I would just flag that. I'd like to share another story. Ian Marks. Ian was 11 years old. He lost his mother, and his father was arrested for a serious crime. No relatives to care for him. He's placed in foster care, where he stayed until he aged out of the system. He didn't choose foster care. It was amid his grief. He was terrified of living with strangers, anxious about the day he would survive, and felt utterly alone. He is haunted by the trauma to this day. But he had one source of hope, his mother. who served honorably in the U.S. Navy. Consequently, Ian was eligible for survivor benefits through the Department of Veteran Affairs and the Social Security Administration. He had hoped those funds would help him through college. He'd hoped those dollars might help him get housing, normal things. But he never saw a dime of those funds. That's because, as he learned when he turned 18 and exited foster care, the very system that was supposed to be helping him had been spending that money the entire time. The state's child welfare agency, without Ian's knowledge, had applied for these federal benefits, received those for years, and used them. Ian has become a champion for change in this practice. He quipped, "If I was paying for my time in foster care, I want a refund." The most recent data that we had access to, Kansas, we showed used about $4.8 million of foster youth supplemental security income, disability insurance, and survivor benefits. This is money that, if allowed to remain with and be used by the child for the child's unmet needs and can serve for future needs, could more directly impact the children for whom they were intended. This bill in front of the committee will protect children like Ian from experiencing what he experienced. House Bill 2552 does several things. It ensures the department properly screens children for eligibility and applies for those benefits. It requires the appointment of a representative payee, and that process is outlined in the bill. In those circumstances where the department is appointed the representative payee, it prohibits the use of funds for basic maintenance costs and requiring the division to only spend the child's funds to meet current, otherwise unmet needs. And it requires the department to conserve the balance of those funds for the child's future needs. Finally, as an accountability measure, it requires reporting related to those funds. This bill is modeled off a comprehensive bill that passed in the state of Arizona last year. It went into effect October 30th. As you heard Amy share, a number of states have done this to varying degrees. The Arizona fix is a comprehensive one relative to what we see in other states. You may be asking why these benefit areas. These are the three most widely utilized benefit areas engaged in what some call benefits management or benefits mining, depending on how you perceive the practice. I'm happy to respond to any questions about how we handled implementation or the structure of that at the appropriate time. Thank you.
Okay, yeah, thank you. So I don't show any further proponents to speak to the bill. Is there anyone here? Okay, we have written only proponent testimony from Tanya Keys with DCF. Yeah, she's here if we have any questions for her. So committee, you've heard from the proponents. Do we have any questions? Representative Lewis.
Thank you, Madam Chair. I'm not exactly sure which of the proponents I should address this to, but my question is, under current law, if you have a rich uncle that, passes away and you inherit $200,000, what happens with those monies if that child is in foster care?
Amy, do you want to address that?
Sure. I don't know if I can speak with specificity to what happens in Kansas, but I will tell you that it would be exceedingly unusual for a child in care to be in that situation, a very fortuitous one. If that child were receiving benefits, they wouldn't really, if that money came to them, they wouldn't qualify for disability benefits because you can't have resources in excess of $2,000 without losing your eligibility. Survivor benefits don't have an asset cap, so that money conserved for the youth. What I can tell you is that in addition to children's benefits, many states actually take children's property beyond their federal benefits. In Nebraska, you're with one of your neighbors. They'll take everything from your livestock to your burial plot, in addition to your federal benefits, not to mention your various bank accounts. So I don't know if I can address it that specifically, but I can tell you that it would be very unusual. And hopefully that money would be available to the child after they aged out of care. I can tell you that we know about 50, average American parents spend somewhere around $50,000 on their children between the ages of 18 and 25. You can all reflect on what you were doing during that time and how much support you might have gotten from your families between housing and health care and education and transportation, not to mention all the emotional support. So when we're talking about conserving these assets, we are trying at least to create some sense of a net for them when they age out, because frankly, most youth who age out of care have a very high chance of exiting into homelessness, becoming incarcerated, becoming parents very early on, experiencing mental health and physical health issues, and experiencing substance use disorders. So we know the outcomes are not good currently. And I should hope that enough youth would be in that situation.
I'm sorry, but I don't understand the answer to my question. What happens when you inherit $200,000 and you're in foster care to that money?
I don't think I can speak to Kansas law. Generally speaking, I would hope that that money would be, in fact, held in trust for the young person until they reach the age of 18, or until they leave care. I don't believe the department would be able to access personal savings account for any costs beyond the cost of the child's foster care, but that also might implicate their eligibility for Medicaid. Most children in foster care receive medical insurance through Medicaid, but if a child had that kind of money in their name, I don't think they would be eligible for Medicaid. So it could be that those resources would be used by the agency to pay for their medical care as well as their current like room and board.
Thank you.
Would you want to ask DCF that same question?
Anyone has
Tanya, could you address
information
that?
about what happens in Kansas? I'd be interested in hearing that.
Thank you, Chair. Thank you, Representative. I don't know that answer. I'd like to get an answer for you in writing specific to your question.
Okay, further questions? Or any of the proponents? Representative Wagner.
Would Tanya mind coming back up on this? I think I mean, I'm tracking with what Lewis, or Representative Lewis, is asking, is that whether it is federal benefits, Social Security benefits, or if it was like a rich uncle, a kid inherited a bunch of money. I mean, the state of Kansas currently treats that the same, correct? I mean, that you hold it in some kind of trust. I mean, from your testimony, it seems that then, the, say, $1,000 a month or whatever the accepted cost of foster care is, that part is taken out, but everything beyond that, you still keep it. I'm reading your testimony. I mean, so the question is just, you do treat private money versus federal benefit money equally for a foster care child, who's in the care of the whatever in the system, correct? Is that?
And Madam Chair and Representative, thank you. I don't know the answer with regard to a personal inheritance that would be private dollars. I don't know that answer. I think the answer also depends on whether or not parental rights have been terminated. So I do think there are some other factors to consider. And I want to be accurate when we give you the answer, so I'm going to ask our team for the answer and we'll get back to the committee.
Representative Howerton.
Thank you, Madam Chair. And I'm not sure who to address this question to. I am curious about line 20 on page 3 about, or to maintain family connections, what that means.
Looks like Kendall is going to
Thank you. And I
take a stab at that one.
Certainly, Chair, Representative. That is essentially if there are visits or siblings, if there's transportation costs to help maintain those relationships, anything that might not be covered by the state to help strengthen that relationship.
And then do you have a definition for care and custody of the child?
We did not introduce that definition in this particular legislation. I mean, the thought is when they come into the care, when the state takes the child, that they would, that this would be effective.
Okay.
Any other questions?
Not for you, I have another question.
Oh, okay.
So I just wondered, is this currently taking place in Kansas today? Or taking federal? You know that? Oh, you know that answer, okay. It does.
It does, yes.
Okay. Tanya, did you have another response?
Thank you, Madam Chair. Representative, I did have a definition of custody as it exists in the Child in Need of Care Code. It is in 2202M. I can read that for you. Custody, whether temporary, protective, or legal, it means the status created by the court order or statute that vests in a custodian, whether an individual or an agency, the right to physical possession of the child and the right to determine placement of the child subject to restrictions placed by the court. Care is not further defined, but custody is defined in 382202.
Would that involve legal fees? I'm just trying to figure out what all care, custody and care is. Is that, so are attorneys trying to get this money as well, or how does that work?
Well, thank you for the question. I may have misunderstood your question. With regard to general care, so it has to do with food, clothing, shelter, maybe some education, that generally the care, the costs of care involve the costs of food, clothing, shelter, placement, those types of costs associated with a child being in foster care. Is that more helpful of an answer?
I'm just trying to determine if the money is being taken for legal fees and applied to legal fees. Would that be an option?
Madam Chair and Representative, if I understand your question correctly, the department does not pay legal fees for the cost of a child in need of care action.
It's just a court-appointed attorney. Is that how that works for the courts pay that? Thank you.
Did you have anything to add to that? Okay. Okay. Further questions? Representative Wagner.
The gentleman there, I'm sorry, I don't have your name, but a proponent. So just again, not to play devil's advocate on this, but if the child was not in the child welfare system and they would be eligible for Social Security or whatever because their dad died or whatever like that, the money that would come to the family, they would be spending it on food and shelter and clothing. Is that not? That's what you would expect, correct?
Yes.
And so is there not a logic that then if the state of Kansas taxpayers are now paying for their food and shelter and clothing, that the money, if they weren't in care, it's not like the money would be accumulating in some savings account for them or something. They would be spending it on their daily needs. And if we're taking over the responsibility of paying for their daily needs, is it that much of a stretch that the money, it is going to their daily needs? It's just going as it would be through the state of Kansas? There's a logic to it.
There is a logic. We would disagree with that logic. It's legal, the practice. The one thing that we would just lift up through this is like these children entering this system at no fault of their own, right? They're abused and neglected. They come into the state's care and custody. The state then takes this property of theirs without any notice or information, and then we assume that the actual expenditures of those funds are for that individual child's needs. And what we're seeing around the country is not a clear amount of transparency and reporting of the expenditure of those funds. And so they're just going from that child into the state's coffers, when really the intent, right, is for that specific child for specific reasons. I think as a principled matter, the state should be obliged to pay for the certain level of care for every child that enters its care and custody, versus having certain children pay for their care and custody.
from the testimony of the DCF is that when the agency receives these benefits, they are used for the child's foster care maintenance, such as food, clothing, shelter, education, and daily supervision, not to exceed actual cost. There are also instances where these funds are requested for miscellaneous one-time expenses. Current accounts are managed through an administrator who oversees what's called the representative payee program. I mean, I guess I would give the state of Kansas sort of a good faith that they're trying to account for what goes for the cost. Stuff above that is still in the child's name for, special events or, such as that. I mean, does that not seem?
Right, and my remarks aren't specific to the state of Kansas. I'm not trying to impugn that the state is somehow engaging in this practice, but to say more generally, we're noticing a lack of transparency and reporting around the country on these particular funds. The state of Kansas may very well be reporting kind of up to snuff with the Social Security Administration and such, but we're just not seeing that.
Okay, I think Amy has a response as well.
On to that previous question with a little bit of information. The Social Security, you're absolutely right. Generally speaking, Social Security disability benefits are intended to support the basic needs of a disabled person. And if a child is to pay for their, but the Social Security Administration has a separate set of rules and regulation that pertain to children who are in institutional care and specifically in foster care. And the Social Security regulation that pertains to this states that if a disabled child in foster care is able to have their basic needs met or is provided under other circumstances to have those basic needs met elsewhere, then their benefits should be used, as Kendall has spoken about, for unmet current needs and future needs. So I just wanted to acknowledge that, you're correct in terms of the way that those benefits, generally speaking, are used. And we do have very clear federal law that states that for every child removed into care, that the agency is obligated to pay for their care. And as you already heard from your director, that includes food and clothing and shelter and other basic needs. So there is a distinction under federal regulation regarding how disability benefits are used for children in care versus children living at home.
Thank you. Any other questions? Representative Humphreys.
Thank you, Madam Chair. I don't think we've gone over all of this so far, but I just want to make sure I understand the bill. So the first part is that the secretary has to determine whether the child is eligible for benefits, and then if they are, they have to apply for benefits. That's kind of the first part. Then the second part is that if the child does receive benefits, that those benefits cannot be used for the care and custody of the child. But they can be used for unmet needs, which would be transportation to work, tuition, tutoring, fees, books, family connections. You could use those benefits for all of those things. Okay, I got it, yeah. So that for the people online, I got a yes from, okay. Well, and maybe, well, then my next question is the fiscal note. I mean, so Kendall, if you want to, or somebody wants to address, the fiscal note is $8.5 million, which I mean, I guess it kind of makes sense because the department is now having to pay for the care of the child that's in foster care, whereas before they were being reimbursed by the child's benefit. So would you care to talk about the fiscal note?
So the center would disagree with the estimate in the fiscal note. I mean, the most recent data we show is $4.8 million. The overall number of children coming into care in the state of Kansas is lower. The other thing to think about is that The state can access Title IV-E funds to administer the implementation of this benefit regimen. So in terms of if they've included in their estimate, not just these benefits, but like, let's say, costs for administering the implementation of this, those should be offset by Title IV-E funds that they're able to pull down to administer it.
And do you know they're not pulling down those 4E funds now?
I'm not aware of their practices related to that specific implementation.
Thank you. Okay, thank you. Thank you, Madam Chair.
Representative Carr.
Thank you, Madam Chair. I do have a question that kind of piggybacks on some of the questions that my previous colleagues asked. If a child, in fact, has funds in a savings account or something of that nature that the state is removing to pay for or to reimburse for what is considered care, does that child have any choice in, I mean, if I'm a child that happens to be in the state's care, and I have some funds available, can I request the fact that that I get iced out? Can I go buy jewelry and a brand new pair of Jordans? Or who has conservatorship over those funds and how those funds are spent? And a two-part question. It was said earlier that particular child would not be eligible for Medicaid because they had too much, they had too many assets, so to speak. Then who is it that makes a determination on what insurance plan then that's purchased for the child? Does the child have any input in the insurance provider, or who makes those decisions? Is that still at the state's discretion? Is there some sort of a tier sheet that the child gets to look at, or just kind of explain that to me?
Kendall
Seal with the center. The second part of your question, I will leave that to the department to comment on, related to their insurance provision. The mechanism in the state of Arizona, at least how this has been contemplated, is that there's a personal needs account up to $2,000 that the money goes into first. Then there's an ABLE account that is opened that is then funded with these resources. The determination, and as it's laid out in this bill, that determination of who the representative payee should be, it's not necessarily the department. And it may not even be an ABLE account. It's supposed to be an individualized assessment of that child and their circumstances. I'll give you an example. You have a child who comes out of a sex trafficking situation. They get restitution funds. They also have a disability and they may be under guardianship. Maybe you go the route of a special needs trust for that child versus an ABLE account. Features of this, I think, are best filled in terms of the administrative rulemaking, but the really important thing that I would hone in on and what's in this bill is that definition of unmet need and cost of care. The cost of care is a federal definition that we use. We didn't want there to be kind of too much wiggle room with regard to what unmet needs meant, but ultimately there should be an internal process for how a youth, and this was foster youth that we listened to about how this should be handled, but they should have access to their funds. Maybe they need a laptop to go to school. Well, the department's not going to pay that, but they should be able to access those funds for that unmet need to get a laptop for their education. That would be one example. But there should be safeguards. One of those safeguards is financial education before they age out of the system so they're not re-exploited.
Okay, thank you. I think I'll let you get, if you want an answer to the rest of your question, you guys can do that maybe offline because we need to move on. We've got to finish this hearing and we have another bill. So we'll wrap up questions on this one. So neutral testimony, don't show anybody testifying orally, but we do have written only from Rachel Marsh with Children's Alliance of Kansas. And then anyone else wishing to testify neutral. You are just being a stinker. Okay. Anybody, I don't show any opponents. Anybody wish to testify as an opponent? Okay, we will wrap up that, close the hearing then on House Bill 2552 and open the hearing on 2554 and ask Jesse to give us an explanation.
Thank you, Madam Chair. Good afternoon, committee again. House Bill 2554 proposes a whole new section directing the secretary to complete an extensive search for relatives or persons with whom a child has close emotional ties when the court orders when the court has an order of a temporary custody of a child. So a temporary custody order of a child. So once the court has done that, then that triggers this process. So the new Section 1 outlines requirements for the secretary to search, identify, and notify these relatives or persons with close emotional ties. In doing so, and in that search, the secretary shall interview multiple people that are close to the child, search within that list of certain databases, and by any other means to identify those relatives or persons. And then within 30 days of an order of temporary custody in each following hearing within the proceeding for such child, the secretary shall report to the court on the secretary's efforts to comply with that first section for that searching and notification as well. And they also report to the court whether identified persons due to that search have accepted or rejected consideration as the child's placement. And then the secretary's efforts to consider such persons as placement for the child, and the unresponsiveness from persons that have received notification due to the search that the child is or has been removed from parental custody. So the section then also speaks to that notification. So the section includes requirements for the notice to be given to the relatives or persons with whom a child has close emotional ties. And that notice will include information on becoming licensed as a foster family or a foster provider. It talks about the financial assistance of being a placement for a child and the general process of being that placement. The notice includes information specifically that if there's a failure to respond within 30 days of that notice, then that person receiving such notice may not be considered for placement by the secretary. And then lastly, this section requires that the secretary continue these search efforts for 6 months after the order of temporary custody. They do it for either 6 months, or if the child is placed, for example, the child's placed within 2 months and before that 6 months is up.
Okay, thanks, Jesse. Are there questions for Jesse regarding the bill? Okay, thank you. Okay, we will open with the proponents and ask Kendall to come back to the podium.
Thank you, Madam Chair, members of the committee. Kendall Seal, Vice President of Policy for Center for the Rights of Abused Children. We brought this legislation to ensure children are protected and have the best chance of stability and family connection. We believe that children should be quickly settled into a relative placement or foster home on the path to permanency. Children who live with family, as many of you have probably heard before, fare particularly well. That is why we support this particular bill. The problem from our perspective is that Kansas law currently provides some judicial oversight of the intensive and ongoing yet unsuccessful efforts made by the department to place the child. But what we feel like it lacks is some accountability and specificity necessary to ensure that there's a prompt and thorough search. And so that's why we kind of spelled it out in this bill in terms of timeframes and databases to look, as well as notice to family members and what's in that notice explicitly and what they're made aware of. So that way, hopefully we don't get into that scenario where we're 18 months down the line and are we still doing the diligent search, or was that just kind of an amorphous process? So it's just trying to give that specificity to the journey of finding relatives. There's a number of reasons, though, that I would just lift up. High level is that Kansas children in need of care lack stability. We put some numbers in there for you to get a sense of where Kansas is measuring up. 79.4% of youth in care had 2 or fewer placements, while 20.3% had 3 or more. Nationally, those averages are 83 and 16 respectively. Kansas children spend too much time in foster care relative to the national average. And also, too often, Kansas children end up re-entering care repeatedly at a much higher clip than the national average, which is concerning. So we believe fundamentally that a child's needs must always be paramount. And in this case, that means finding relatives quickly at the beginning rather than the end of any case. It means prompt placement with relatives whenever possible to avoid trauma and the constant moving of homes. These are simple and necessary steps that we believe this legislature can undertake to ensure every child deserves a safe and loving home. Thank you.
Okay, thank you. Kendall, you might as well stay. I don't show any other proponents. We do have written only from Tanya Keys with DCF. So, committee, do we have any questions regarding this bill? Representative Humphreys.
Thank you. Do we happen to get a copy of the bill? Thank you. So could we have just a second?
Yeah, go ahead and take a second to look at the bill. Representative Howerton.
Thank you. I'm just looking at the, thank you, Madam Chair. I'm looking at the fiscal note. So DCF needs additional software. Do you have any input on that, Kendall, or are you familiar with why it would be?
Our understanding is the department should already be conducting a diligent search. This is primarily setting some timelines and expectations. And I mean, we think a diligent search, these are kind of the floor for what that should look like. And if they want to go above that, that may look differently, but yeah.
So, okay, thank you.
They also are developing new software at this time anyway. So, yeah, right, that we're already paying for, yeah. Okay, any other questions? Representative Humphreys.
Yeah, what I wanted to look at was just some of the timing. So I'm seeing in section 1, 30 days, within 30 days of the court order, that would be the court that the child is adjudicated a child in need of care. Mm-hmm. That order is what you're talking about?
Yes, ma'am.
Okay. And then, if I may, thank you. And then whenever there's a subsequent hearing, there has to be sort of an update on what's happened, it looks like. And then what is the time limit for how long the search is going to go on?
So we looked at 6 months, giving a 6-month window for that diligent search to be undertaken. Our thinking behind that, I mean, aside from there's a number of things in the law, and even in other areas of the law related to 6 months and child custody and such, but the main one being that you've placed a child with a family and we want to promote permanency, and having a child, you know, after they've been with someone for 6 months, start bouncing around is something we are trying to prevent. But we want to hold out hope that a family member can stands up and says, you know, I want to be there for my relative, and this is what that looks like explicitly in terms of the notice.
Do you define close emotional ties in this bill?
No, we do not.
Jesse, is that defined in our statutes?
If I may, on that specific line, we were trying to deal with a kind of broad understanding of kin. Federally, it could be a neighbor who has a close emotional tie to the child who would raise their hand and show up in that way.
Jesse?
Thank you, Madam Chair. So the definition section code for the sync code does not have a definition for close emotional ties, but there are definitions that use that phrase. And so the definitions that use that phrase are kinship care placement, which means the placement of a child in the home of an adult with whom the child or the child's parent already has close emotional ties, kinship caregiver, which means an adult who the secretary has selected for a placement for a child in need of care with whom the child or the child's parents already have close emotional ties. So I would lean on court interpretation or case law as far as what those factors may be to determine close emotional ties.
Okay, I'm just thinking of a situation where a child is has been in foster care, but they're reintegrated with their family. Everything's fine, but then maybe they are adjudicated again as a child in need of care. So by that definition, those previous foster parents would need to be included in this list if they have, if they've shown that they have close emotional ties with them. And the reason I'm even bringing that up is because at times we have thought of redefining that kinship care to mean a foster family that the child has lived with for more than a year. We've kind of tossed that around. So I'm just trying to think through what this means and what it would mean for children and foster families. Yeah.
Absolutely, and I think anything that's child-centric and that looks toward those dynamics with foster parents or others that they may have that close emotional tie is completely appropriate.
Thank you. Thank you, Madam Chair.
Further questions? Representative Howell.
A couple, thank you, Chairwoman, I should say. A couple of, I think, fairly quick questions. One is, has this been passed in other states?
Chair, Representative, yes, it has. It's passed in Arizona, Missouri, Tennessee did a relative search, and now Kansas is advancing it.
And then secondly, this is a little bit of a side question, but curiously, is a DNA search done at all in this kind of thing? Do you have any kind of clue? Like, do they, like 23andMe, looking for relatives? I'm just kind of curious now. The things you start to wonder about up here is a little insane.
I think that's a great question. Actually, I'm not aware of a department doing a 23andMe search kind of in this vein, but I do think that the use sometimes the integration of social media has been very helpful in a number of ways, whether it's relative search or finding missing and trafficked kids. So I think that would be some creative response to finding relatives.
Other questions? Okay, thank you.
Thank you, Chair.
Okay, any other proponent testimony that I don't have? Okay, we have neutral testimony from Rachel Marsh that is written only with Children's Alliance of Kansas. Any other neutral? I show no opponent. Is there anyone who wishes to speak as an opponent? Okay, seeing none, I'll close the hearing on, House Bill 2554. All right, somehow or another, we finish up on time. Jesse, do you have? Okay, yeah, Jesse, go ahead.
Thank you, Madam Chair. This is, I have some information regarding the first bill, 2552, in relation to Representative Howerton's question about legal fees and kind of those court costs. So when we're thinking about legal fees, the guardian ad litem and or a second attorney may be appointed pursuant to 382205. And then the reimbursement for those attorneys and docket fees is dealt with 382215. And there it states that those expenses are to be reimbursed at the approval of the Board of County Commissioners from the general fund of that county in which that case is brought.
Representative Ousley, did you have a question?
If it's appropriate, if Amy's still online, we ran out of time asking questions on 2552. but I was going to ask in regards to the testimony submitted. It mentions Oregon and Minnesota went as so far as to propose a path to financial restitution. And I was curious if you knew a fiscal note or a fiscal impact upon that, as the fiscal note for 2552 did come up in questions.
Amy, are you still on? Oh, we let sorry, we cut you short. Kendall?
Certainly, I'm happy. I don't know that off the top of my head. I'm happy to look at it. I know the center's advancing this particular reform in a number of different states, so we're looking at their data, or the most available data that we have. So I'm happy to follow up on that.
Thank you.
Thank you,
Madam Chair.
Sure. Okay, committee, so Monday, we're going to have hearings on those Child Death Review Board. One's from the Child Death Review Board and one from DCF regarding child death. And Wednesday, I don't have, what did I, oh, we have an informational hearing on the governor's proposal. It'll become a bill hearing as soon, when we have the bill number. We potentially will have an extra day next week, depending on the committee that meets in here on opposite days. They are potentially going to finish their work a day early and allow us to have an extra day. So if that's the case, we'll certainly use that day. Otherwise, we're going to be really busy on the next Monday, the 19th. So see y'all Monday. Thanks.